So as I said earlier, it is my pleasure to host this webinar at which we will highlight the findings from International Legal Assistance Consortium's new discussion paper entitled Access to Justice for Vulnerable Groups in Times of COVID-19, Libya. The new discussion paper assesses how the COVID-19 pandemic has affected access to justice for vulnerable groups in Libya. The pandemic has added another layer of complexity to accessing and delivering justice in an already unstable context. Despite these difficult circumstances, the Libyan legal community has remained very resourceful. It has managed to navigate in this fragmented judicial system and stay in contact with the most vulnerable, which requires both intelligence and courage. The ILAC discussion paper builds on a series of in-depth interviews with legal professionals in Libya, conducted by ILAC members and the American Bar Association Rule of Law Initiative, as well as the Public International Law and Policy Group. At this webinar today, we will focus on some of the key issues highlighted in the discussion paper, which include gender-based violence, women's and girls' rights, digitalization of the justice system, as well as legal aid. Before we begin, let me go over some housekeeping items. First of all, regarding language and translation, I think we have clarified that it is working, but for those of you who are just joining us, at the bottom right of your screen, you have the interpretation label on your Zoom screen. You can select English or Arabic and follow this webinar in either language. If you have questions for our panelists, and I promise that we will get to your questions, please use the chat function. The chat function is at the bottom middle of your screen. Please feel free to send us your question and at any time during this webinar, and I will do my best to weave in at least some of your questions. We will also post links in the chat function to the English and Arabic versions of the discussion paper. So please feel free to consult those. If you don't get them from the chat from this webinar, you can also go on the ILAC website, or you can also look up all of the ILAC social media channels, and you can find copies of the discussion paper in both languages. And last but certainly not least, this webinar will be recorded, and after it is recorded, it will be posted on ILAC's social media outlets. With that in mind, it is my pleasure to introduce our first panelist, Nina Tsutoria, who is the ABA Rule of Law Initiative country representative to Libya. Nina will begin our discussion and share some introductory words with our audience. Nina, the floor is yours.
Thank you, ladies and gentlemen, dear participants. On behalf of the American Bar Association Rule of Law Initiative, allow me to welcome you to webinar Access to Justice for Vulnerable Groups in Times of COVID-19, and congratulate ILAC and its partners and contributors with the publication of the report with the same title. Although many of you know about ABAROLI, let me briefly summarize our work in Libya. ABA's Libya program was launched in 2012. We have a long-standing cooperation with justice sector institutions, particularly Ministry of Justice, the Supreme Judicial Council, Bar, and Young Lawyers Association. ABA really worked with partners to design and implement trainings and workshops for judges, prosecutors, lawyers, and community members on different topics, including international standards in pretrial detention, rights of migrants and asylum seekers, investigation and prosecution of series of transitional crimes, such as cybercrime, money laundering, trafficking in human beings, freedom of speech, and so on and so forth. Under the ILAC program, ABAROLI assists Libyan legal professionals and civil society organizations to design and implement civic education activities. Apart from the program that led to this report, during the pandemic, ABA supported Libyan partners from the governmental institutions and civil society organizations to raise awareness about COVID-19 and tackle COVID-related disinformation and discrimination. The purpose of the COVID report is to assess the impact of pandemic on vulnerable groups' access to justice and identify the trends. It is one of the 3 reports focusing on access to justice for vulnerable groups in times of COVID-19 that ABA contributed to. The report on Tunisia has been published. The report on Palestine, which covers both West Bank and Gaza Strip, will be released in the autumn. As noted, the report on Libya builds on a series of in-depth interviews with legal professionals conducted by ABAROLI and Public International Law and Policy Group. 11 interviews were conducted by ABAROLI in December 2020, followed by an analysis of collected information. The special questionnaire designed for this program focused on 3 areas: access to justice for vulnerable groups, legal aid and representation, and access to legal information. We are grateful to ILAC for this opportunity. I also like to extend my gratitude to the lawyers who participated in the lengthy interviews. And I hope that many of them are with us today. Today, we will discuss the findings of the report with particular emphasis on gender-based violence and the rights of women and girls, digitalization of justice system, and legal aid. The COVID-19 pandemic posed new and unprecedented challenges to all legal systems, whether national or international, developed or less developed. No surprise that vulnerable groups in conflict-ridden contexts were particularly affected. Libya was no exception. Importantly, Libyan legal community, including judiciary, made efforts to navigate through these unparalleled challenges. We'll be able to hear more about these efforts during the webinar. We all agree that the magnitude of the challenge posed by pandemic requires continuous local efforts and substantial support from the international community. In this regard, I'm pleased to announce that ABAROLI has recently started the Supporting Responses to Gender-Based Violence program, funded by US Department of State's Bureau of Democracy, Human Rights, and Labor. Along with outreach campaign raising awareness about gender-based violence, the program aims at developing capacity of lawyers to provide legal aid to gender-based violence victims and support the Ministry of Justice, especially its newly established Women Empowered Unit, to develop process for expedite and victim-sensitive handling of gender-based violence cases. In conclusion, let me express hope that the report will become a useful tool in assessing Libya's course to move to stability and rule of law during this historic moment. I thank you for your attention.
Thank you for those introductory words, Nina. Next, we're going to turn to Ilva Hartman, legal advisor at the International Legal Assistance Consortium, and Ilva will present us with the findings or some of the key findings of the report. Ilva, the floor is yours.
Thanks a lot, Milena. I will share my screen also for a PowerPoint presentation. I also want to thank PILPG and ABAROLI for the cooperation with this report, but also the cooperation we do together in Libya. But even more so, I want to thank all the Libyan legal professionals that have been interviewed for this study. I am deeply impressed by your work and commitment, and I know some of you are here today as well. So a big thanks to you for helping out with this study. So as has been mentioned, I will present some of the findings of this report. And we are focusing on vulnerable groups' access to justice for everyday justice needs during the pandemic in Libya. And what we mean by that is disputes encountered by regular people in their daily lives. I think it's important to stress in a context like Libya that we focus on this. With such a heavy track record of grave violations of human rights and humanitarian law. But this is not the focus of our webinar today. So as has been stressed, we have done in-depth interviews and a written survey as well. And it has been difficult to obtain data. And I have to also stress that we don't intend in any way to be exhaustive or make a representative claims of what the bigger legal community in Libya thinks. But this is just to provide some insights into the realities of vulnerable groups' access to justice and the legal professionals' work, and also to start and spark a discussion on these issues and give some initial recommendations on the way forward. And what I also want to stress in the beginning is that one aspect that was that stood out was also that judicial services were completely closed during 3.5 months due to COVID-19. And after that, there was also the regular judicial annual holiday. So this created both backlogs of cases naturally, but according to respondents, this also created fear and a sense of lawlessness, which was particularly strong among vulnerable groups. And this also aggravated the general sense of impunity in Libya. So today we will focus on 3 aspects, and that has already been stated: gender-based violence and women and girls' rights, legal aid, and the digitalization of the justice system. So first, on gender-based violence and women and girls' rights, one group that was highlighted by the respondents in this study was single mothers and their children. Many had cases of outstanding alimony during the pandemic, and this caused catastrophic consequences in many cases. People lost their homes and were unable to buy food and so on. And what respondents reported was that there was also a lack of knowledge among women on their rights upon divorce. Often they didn't know that they were entitled to use the marital home, for instance, that they were entitled to child support, or even that they had custody rights. So one of our recommendations is that it is very important to spread information on rights upon divorce. So respondents also stressed that both domestic violence and child marriage needs better protection, national legal protection, in particular since they noticed an increase in both domestic violence and child marriage during COVID-19. And this has also been confirmed both globally and also in Libya by other actors, UN agencies and civil society. So some concrete steps that could be taken, or first steps, is also to adopt a comprehensive legislation on gender-based violence. And there is one draft of a legislation that was started at drafting in 2017, but it is necessary to work on updating that legislation and also adopting it. And also we recommend to amend the Law 10 of 1984 to abolish child marriage. And so moving on to the second point in this presentation, and legal assistance and representation. This naturally decreased also a lot during the pandemic, and the respondents were very worried about this, and they pointed towards the importance of public lawyers and civil society to support in legal assistance and representation. And we were particularly interested in the role of public lawyers and the Department of People's Legal Defense. they had this mandate to provide legal aid at the cost of the state in some particular cases, such as custody and some urgent cases involving, for instance, alimony and visitation rights. And already before the pandemic, this public lawyers were under-resourced and also had difficult access to some parts of the country. And it is also up to victims to contact the public lawyers. So what we recommend is that the public lawyers, that they get more funds to do outreach and also to more proactively engage with communities to increase access to their services. So what we recommend is then to invest in the Department of People's Legal Defense, also to encourage the Libyan Bar Association to provide legal aid, and also to liaise with civil society legal aid initiatives and to support legal aid networks in general. And we also need to have a better information and awareness raising to the public on the availability of legal aid. And this is, and it is quite obvious, but it is a very crucial issue to access to justice for vulnerable groups. And moving on to the third point of this presentation and the digitalization of the justice system. COVID-19 made clear that digitalization is needed to improve access to justice in Libya. Respondents in this study, they were all enthusiastic about digitalization, but they were also very cautious about it. Digitalization is tricky in a country like Libya, where power cuts and internet disruptions are common. So what we therefore recommend is that it is very important to do a thorough mapping of the conditions of digitalization. That includes also digital literacy and infrastructure. What we also recommend is to prioritize online access to case information, online access to legal information, in short, on hearings and so on, being cautious about safeguarding the right to privacy and cybersecurity. And also to match this with outreach to vulnerable groups and complement the digitalization with other analog channels. So vulnerable groups could get, with scarce access to internet, also can get the information. And so the reason why we focus on access to legal information instead of, for instance, remote trials, is that legal information is much less sensitive to power cuts and poor internet connectivity. When for a remote trial, a lot is at stake, such as one's effective participation and fair trial rights. We don't rule that out in any way, but we recommend to prioritize this online access to legal information, because this is also what we've seen, that access to that type of information is very pressing for justice seekers. This we saw that in Tunisia as well. So it's a demand from this justice seekers, so to speak. And I have underlined it, but I have to underline it again, that these recommendations are only very initial and first steps, and of course more structural solutions are also needed, and COVID-19 can also provide an opportunity to open up that debate. And in that context, I also want to flag that we recently published another policy brief on justice for gender-based violence survivors in conflict-affected and transitional settings that do address some of the more structural issues behind countering gender-based violence and also attached to the digitalization of justice. and you can find that on our webpage. And I think this discussion on first steps and structural solutions is a good way of opening up the debate with the other panelists. And I also want to end by saying that Libyan authorities, and in particular the Government of National Unity, will also need the support of the international community in doing this, as well as both Libyan and international civil society actors. Thanks a lot.
Thank you so much, Ilva. Next, we will turn to Zara Langi, who is co-founder and director of the Libyan Women's Platform for Peace, and also a member of the legal committee at the Libyan Political Dialogue Forum. Zara, the floor is yours now.
Thank you. Thank you, everyone. Thank you, Elva, for the presentation of the report. I will pick it up from your last comments on the report that I unfortunately have not seen, the one on conflict settings. And actually, this is where I wanted to start because I had no idea about how you've decided to focus on these areas of priorities, leaving others, and what was the question guide that was sent out to the respondents. And the first thing that actually struck me is that the lack of the conflict analysis. And the focus on, even on gender-based violence, the focus on certain issues, leaving out other issues. Of course, gender-based violence is different than conflict-related violence, but both thrive on each other, especially in a conflict setting like Libya. And I was wondering if there was a more conflict-sensitive analysis in the research, the recommendations would have been slightly different. What I've seen in the focus, first of all, yes, definitely, Yani, when you say gender-based violence and then the rights of women and girls, it's a lot to cover. But then when you read the recommendations, that focuses on certain areas, leaving out many areas. And particularly the conflict setting. And we do know that that gender discrimination underpins all conflicts, and armed conflicts undermine women's rights and threaten their security. That violence against women and gender-based violence rises during armed conflict. The other issue is, on one hand, you say gender-based violence, and then the focus on women and girls. There's focus on the shifting of gender roles during this transition, if you don't want to even call it an armed conflict. So all of this is taking place and is influencing the legislation movement in the country. Women, there's this phenomena of emasculation. So it's the conflict outside in the public areas influencing the private areas, the rise of domestic violence. Women as well are being used as a tool for war. subjected to sexual enslavement, trafficking. Issues related to conflict, I think, are very much needed to be, and I have no idea why the siloing, having another study on armed conflict, and this is only on gender-based violence, but then and it's in the last 10 years in Libya, but doesn't address the violence in Libya. I think also I've seen issues, even if we're not addressing conflict-related sexual violence, but the trends and patterns, trends of patterns of gender-based violence, I don't see it in the report. Especially the political violence against political women. There is also, if we're talking about gender-based violence, I don't see, it's many kind of violence. It's economic violence, social violence. So I don't see addressing the whole gender bias, the harmful gender norms, the structural barriers, also I would say a lack of intersectional lens in analyzing the forms of discrimination and gender-based violence. I don't know, Yani, there is no, unless the focus is on private and domestic violence, but there is no even recommendations addressing the kind of violence women face from their being discriminated against from the meaningful participation and leadership, whether it's in economic or political or peace, security, humanitarian sectors. The other thing, I'm not sure the recommendations are, I see that they're addressed to Libyan authorities, but I think a lot can be also addressed to international assistance or interventions that are being addressed in Libya. So that's another issue. I think we need to also have a gender analysis, a gender sensitive and gender and conflict sensitive analysis to all the international assistance as well, because it's always lacking when we talk about gender-based violence or conflict-related sexual violence. There's nothing addressed or being covered when it comes to international assistance. So I think these are issues that should not only be dealt with addressing Libyan authorities, especially in a context like Libya at the moment. I understand that your focus is legalistic, but then we do have a problem of justiciability in Libya. Most women who have been victims of either gender-based violence or conflict-related violence, there is no accountability, there's no means of justiciability, the state is not responsible, but then you have the militias, you have the international community, how the UN mission is addressing this issue, what are they doing to make sure that there is justiciability, there is that these violations are being reported. We can say that the level of reporting and violations and justiciability is very low, and that's due to many aspects which are structural, which are normative, social stigma, but then how are we going to deal with it? I don't see that being addressed, honestly. Also issues, the intersectional, again, aspect, what women are we talking about, what age, what category, IDPs, refugees, again, there are many elephants in the room, and I don't see an attempt to address them. So honestly, I don't know where to start and to give recommendations, because yes, you talk about from a legalistic, the recommendations here, legalistic, but pretending Libya is a normal state, ignoring completely the fragility and the collapse of the state. So they're no different than recommendations given to Libya 10 years ago. So I think a lot needs to be unpacked. And maybe that is could be done with a consultation with local actors on the ground, asking them the priorities of research, what needs to be addressed, what has not been addressed before in other policy reports. I don't mean to be, I've been already hard, but I can't see what areas that this policy brief is basically leading us to. It's, I think a lot needs to be done in addressing what has not been addressed before, and especially having a more conflict gender sensitive analysis. I think that's completely missing here, and that's definitely needs to be addressed. And the topic is very vast. To say just gender-based and women's rights, where to begin with. So I cannot be that helpful, but I'm only outlining, I'm sorry, the gaps that I see. And maybe we'll leave it to the discussion. I don't want to take more time.
Thank you so much. We will definitely have more time in our second round of comments to return to much of what you have just highlighted in your comments. Next, we're going to turn to Elham Saudi, who is co-founder and director of Lawyers for Justice in Libya and member of the Libyan Political Dialogue Forum. Elham, welcome, and the floor is yours.
I always have to remember to unmute even after a year of doing this. Thank you all for having me and for what I see as an introductory conversation. I mean, I see this paper, if I may categorize it as such, as an appetizer of what more ILAC and others can do on this topic, and not sort of a final word on it. And so I'm approaching it with that perspective. I've been asked to look at the report and its findings from two perspectives. One is the question of access to legal aid, and the other is the use of digital justice, if I may. But before I do that, and perhaps following on from what Zahra says, I'll make a general comment about access to justice in Libya, if I may. I know we're discussing today the impact of COVID on this question, and that is important, and I'm not detracting from that. But what is also important is to note that questions of access to justice long outdate the pandemic in Libya, and for vulnerable groups especially, long outdate the conflict we are in, and long outdate Libya's 2011 revolution. And so these are, these are sort of systematic issues, and these are pandemics, if you like, in their own right, that have sort of overwhelmed us as lawyers in the country. So I think it's important to keep that in mind. And for me, one of the things I'd also say is that what I think COVID has done is perhaps for the short period provide a credible cover for the shortcomings of the justice system in Libya. And I think it's worth keeping that in mind. And also when we're thinking about solutions and fixes to these shortcomings, that we think of the long-term consequences, because my fear is in framing these issues as short-term issues that have come out as a result of the pandemic, like, the 3 months shutting down of the legal system. Really, the legal system in Libya has been shut down for the last 6 years. And so I think to kind of frame it in that way, then the solutions might also be by nature short-term or short fixes. And I think it's important to think of any suggestions we make that they're also long-term in their perspective, because this is a very much a long-term problem. So to turn to the matters I was asked to talk about, which is to look at this question of access to legal aid. I think the sort of, again, the ability to access legal representation, I mean, I will say this as a lawyer, as a human rights lawyer, is a fundamental right and a fundamental element of due process. And so it's important to say this up front. And I know it's obvious for most of your audience and definitely for most of your members, but I think approaching the solutions to this with that frame of mind and a human rights-based approach changes the solutions we think of and moves them away from, well, wouldn't this be great if we could do that, to more, this is absolutely a necessity because we're guaranteeing fundamental rights here. By way of background, very quickly, legal representation in Libya, as in many countries, comes in the form of either a privately appointed lawyer, if you can afford it, or a publicly funded lawyer, with the latter obviously being provided by the state. One thing that I think is also worth mentioning is that system of public lawyer, or a state appointed lawyer, only works if those lawyers have genuine independence from the state, and actually show up and represent you. And there is a lot of evidence in Libya, unfortunately, that is not the case. And you might get appointed a lawyer who then never shows up to the proceedings, is not there, and therefore the idea that this exists as an option doesn't necessarily mean that it's operationalized in the correct way. One of the key obstacles to access to justice set out in the report is that, according to the interviews conducted, individuals seem needed to contact public lawyers themselves. I think that's a point that Ilva made as well, as opposed to being referred to them by the state institutions. And I think that, again, that's another thing, is that it should be something that is provided by the state and not something that you have to request. This, of course, puts those who are not aware of the availability of legal representation at a very serious disadvantage, because it relies on you knowing that this exists to access it. And this is especially severely realized in Libya in the case of migrants and refugees who are utterly unaware of this. So yes, I agree with Ilva's concept about needing to raise awareness of these services, making them available, and this is suggested in the report. There is a role for civil society here, but I think, again, as a human rights lawyer and as a civil society actor, obviously we relish the moments to kind of step in and do this, but it shouldn't, as a result, abdicate the state from its responsibility to provide this, to provide it correctly, and to make people aware that it exists. And one of the things I would always emphasize is, when making recommendations, it is great to highlight the role that civil society can do, but that shouldn't be in lieu of the state. What we do is optional, what they do is mandatory. And I think that needs to be clearly distinguished. Some of the other areas that were considered, maybe we'll talk about them in the wider conversation. But yes, the issue of kind of education and providing some sort of frontline services like initial legal advice or legal aid provided by lawyers. There are several who already do that, CSOs in Libya, who provide sort of paralegal services for people But one point I'll take here, and it builds on what Zahra said, is, and I understand that the mandate of the report was very limited, and so I understand that it's looking at the pandemic and specifically the pandemic, but discussing these options and discussing these remedies for this problem in a vacuum is confusing, because you know, the systematic problems exist, and although the civil society or others can step in to fill a void, I think what we're in danger here, where you're dealing with a failed state like Libya, is you end up with us becoming the de facto institutions and de facto providers of the services. And that's not sustainable, and that's not accountable, because you need a state that you can hold responsible for these requirements. And so I think it's important to differentiate between complementary services and fundamental services. So the report highlights the impact of COVID on this issue of legal representation and access, but I might phrase it slightly differently, that perhaps COVID has just brought matters into light more starkly, of the problems with accessing legal representation that already exist. I would say fairly comfortably that the problems faced by vulnerable groups, especially migrants and refugees, were serious before the pandemic and were serious before 2011, because it just the framework is not there. And my concern here is that we provide a legitimization of this obstacle by attributing it too closely to the pandemic. Looking at the question of digitalization, I'll own up front, I'm a confirmed Luddite, and so I will admit that when I saw the words digitalization of the judiciary, I kind of hyperventilated a little bit and got quite nervous. I think what is important to help me and others like me breathe is to define what we mean by digitalization, because I think, you know, that's something that's not quite clearly pointed out. And as I read the report more, it became clear that what we're talking about here is more the administrative function of justice as opposed to the delivery of justice. And I think that can help people like me, lawyers, human rights lawyers, exhale a little bit. One, that we're not becoming redundant, but more importantly, too, that there's certain safeguards that won't be sacrificed as a result of this process. And for me, yes, things, you know, that are, you know, obviously are useful are things like having effectively an electronic court register is what's being sort of proposed here, I think, which is, you know, making the case status available, making certain administrative procedures clear online, that you can access them, that you can file things online, etc. And actually someone asked a question I just noted now of asking whether the laws are available online. And the answer is no, they don't exist in any official capacity online. You might find that certain institutions, so for example, the ministry, the housing ministry will have the laws that are relevant to it on their website. But there isn't like a central depository of all law that you could kind of search or find. So that would be an obvious an exercise that would be useful to do. But as a lawyer, I'm trained to think of what can go wrong. And as a human rights lawyer, I'm trained to think of where the state can go wrong. And so I think for me, thinking about the sort of the full spectrum of how digitization could work and how making people's data somehow uploadable onto an online system that is centralized in some way, that may provide states with sensitive data about their citizens in a state where there isn't necessarily the trust or the protections of human rights available, is very concerning. And so I think it's worth taking a while to think about. Yes, expediency is good. Yes, expediency is desirable. But when you don't have essential safeguards about protecting data, we have no data protection laws in Libya, for example. To then for people to be uploading their data online and not knowing what's going to be done with that data, if it can, you know, even the host could be sharing it, could be selling it, whatever, there's no protections at all. And so I think for me, what I'm thinking about here is the potential misuse of this and how we could safeguard against that before we kind of dive wholeheartedly into taking people's data and placing it online, even basic data like, you know, people's date of birth, their any kind of physical ailments, anything medical data, which probably would be part of a, say, domestic abuse case or something. That could all be very sensitive data that is there available to be used and misused. And the other thing, and I think it's touched on the report, and I'm dutifully bound to mention is when we're thinking about tools like this, we need to make sure that they're genuinely used to facilitate access and not to obstruct it. And by that, I mean, you know, accessibility and convenience are good, but for some vulnerable groups mentioned that who may not be able to access facilities like these, who have certain barriers of entry from the cost of having internet access, of the cost of electricity, guaranteeing electricity, then actually what you might be creating is further barriers of entry for your most vulnerable groups. And again, here I'm thinking of migrants in camps, etc., who might not have access to any of these things. A further element, obviously, is the right to be present in hearings. And remote hearings may work. And I know that there was some trepidation when that was mentioned in the report itself, but we've, you know, in the very limited times where we have seen, there was an attempt of video testimony to be used in judicial cases in Libya, that has not been successful. That has failed miserably, actually, with, you know, people not being able to participate fully, etc. And there, again, you're playing with far more fundamental elements of people's rights and their ability to represent themselves and hear things and be present. So I really want to open this up for a conversation because I'm thinking, you know, of the questions I'm putting here and the questions I want us to discuss is not really if we do this or if we don't do this, but how we do it in a way where it is really used as a tool for the individual and not as a tool for the state.
Thank you so much for those comments. And I think you're absolutely right to mention that when it comes to some unstable or failed judicial systems, that COVID-19 could be sort of an easy cover, right? You can blame lots of things on COVID-19 and say, you know, in normal times this works really well. However, it's COVID-19, when in reality, things are not working so well. We do have a few questions from the audience, but before we address any of those, I would like to give our panelists the opportunity to weigh in again, to either make additional points or to address anything that some of their co-panelists might have mentioned. And I would like to first go to Ylva and invite her to comment perhaps a little bit more about the report. You know, we have heard from Zara that obviously there are some issues that she has spotted regarding the report. And I want to make this a very, you know, constructive and productive discussion and invite Ylva to comment on some of those things, but then also perhaps suggest some sort of ideas and solutions looking forward so that we can all put our brains together and truly help those who need access to justice in Libya. So Ylva, please go ahead.
Thanks a lot, Milena. Thanks to Sarah and Elham for your interventions. It was very interesting to hear your perspectives, and I'm thankful also to Sarah to bringing out the elephants in the room, and I just also need to stress again that this study came from discussions with our partners, PILPG and ABAROLI, with Libyan legal professionals, and we developed this questionnaire together with them, and we had limited possibilities in making more interviews. So this is what resorted from those interviews, and also that is a caveat, and it is a start of a conversation. And of course, I mean, I don't, or we don't intend to solve patriarchy in a 30 pages long report either, and even less so in a context like Libya, as you stress, with also the conflict and transitional justice and so on. So it's to stress that again, that this was coming out of the few conversations that we had the opportunity to have, and that we wanted to also to bring the legalistic vision to the table, as you say, but we don't ignore the other perspectives, of course. This is, as mentioned, the start of a conversation, and when it comes to intersectionality, we acknowledge, of course, and it was also a bit difficult to make the sort of the disposition of the report, because we also addressed some other groups, but it was also to be true to the data we got. And when it comes to sort of, we intend also gender-based violence, or we understand it as rooted in gender inequalities, and not necessarily only, I mean, the legislation also need to cover other, not only women, of course, and the UN Women definition encompassing all of the different aspects, as you are mentioning, such as economic violence, verbal violence, and also what I know that Lawyers for Justice in Libya, you have recently released a report on, for instance, online violence against women, which was a very interesting report. So just to say that we are here to start a conversation and sort of just to respond a little bit to that. And when it comes to the conflict lens, of course, it is problematic. I mean, the mere fact of having two different frameworks, human rights law framework and international human rights law framework, is discriminatory often towards women, because it doesn't recognize the structural discrimination and the continuum of violence that women are subjected to. So just to put that on the table as well, and thanks for bringing that up. And when it comes to also Elham, completely agree with the interplay between civil society and this sort of state responsibility, and the need to not substitute the state when it comes to responsibilities and the duty bearers function. So that was just a quick reaction, and thanks for that.
Thank you so much. Nina, would you like to weigh in?
Just a few words. I would like to thank other panelists for their intervention and live discussions. To me, this report is just snapshots. We all know the issues with judiciary, not only in Libya but all over the world. There are too many challenges, and it's not limited only to one particular context. And in relation with Libya, for example, there is long reports prepared by ABA a few years ago, judicial assessment of Libyan legal system, which is about 200 pages report, and it took about 2 years to develop. So there are too many reports, and this is just complementary. Of course, interviewing 11 lawyers does not give the full picture. It's just touch to the system, and actually with the flavor of what happened after the pandemic. So this is a good start. This is another paper in line with any other documents, and it should contribute to discussion. This is the whole purpose, in my view, of this paper. And this discussion is another proof that this is valuable document in this context. And of course, it should generate more and more discussions. And we are planning to use this report for other events as well, and move on from there on, and with the eventual purpose that this report and many other reports in the area will be used by other donors, and first of all Libyan states, to move forward and to make substantial and fundamental reforms. Those are difficult reforms, and it requires cooperation within Libya, within government, within civil society organizations, and the support from the international organizations. That's why we are here, and we can contribute as much as we can. So this is teamwork, and hopefully it will lead us to desirable results. Thank you.
Thanks so much, Nina. I'm going to go to Elham next, and then for the second round of comments, we'll go to Zara last, and then we will, after that, address some of the very excellent questions that we have received from our audience. Elham?
I got a chance in my intervention to pick up on what others said, so I won't use up the time. I'm really hopeful for good questions and a proper conversation, so I'll wait. Thanks.
Excellent. Zara?
Yes. Hello, it's muted, sorry. So it's the same thing, Yani. I would like to take the chance to indulge with in conversation with the audience.
Great. With that in mind, I would like to begin with the following question. And this is a question that is addressed to us by Nina Lahoud, who's actually an ILAC board member, but she raises actually two excellent questions. So let me start with this. Given the lack of sufficient awareness by women and other vulnerable groups on their legal rights, including on issues of gender-based violence in custody, I seek feedback on the following. Number one, the extent to which Libyan laws and orders have been digitized and posted on a website for easy access by the population. So let's start with the first question. We have already mentioned digitization, and I believe that it was Elham who talked about, it depends on what the definition is. So, this is to all the panelists, so I don't know who wants to weigh in on this one perhaps, but are you familiar, do you know whether Libyan laws, orders, other regulations are actually widely available on the on a government website for easy access? Elham?
No, I actually picked up on that question in my initial comments, but the short answer is no, there is no formal platform where this all exists. In some instances, but very sporadically, a ministry might put on their ministry's website the relevant laws to them. So for example, the example I gave is the Ministry of Housing might put the relevant laws, but even then actually, purely practically, you might click on it and it won't take you to the law, or it might even not be up to date. And like very basic things like the Constitutional Declaration, which is the most fundamental law in Libya, actually your most reliable source to find the whole thing is probably Constitute.net or something like that, as opposed to a government-based thing. So yes, Nina, I think a very sound initial project for digitization, and one where it's safer from a human rights perspective, is to make laws available in a digital format.
Can I interject here, please?
Of course.
I would ask, instead of answering the question, I would ask another question. It all depends on the electricity, whether there is electricity cut in Libya or not. For most of the time, especially in certain areas, if we're talking about vulnerable groups, they don't have electricity to begin with. They don't have access to the internet. So it's actually, you want to fix the problem of access to justice through another medium, which they completely lack, which is a luxury for them. And so that's the first thing. The other thing is, do they know, first of all, the importance of legal support, of resorting to justice? Do they have trust in these institutions? That's another thing. So that's why I talked about the elephants, because it seems that we need to know the context and the people who live in the context, who they are, what are their priorities, what are their needs, what do they lack, and make justice and the access for justice for them a concept that they really want to know more about, and then not to make it difficult for them and talk about the digitalization of justice or legal system. That's beyond the needs of Libyans at the moment. And the other thing is the concept of trust. Do they trust these institutions? What role does law play in the life of Libyans, let alone these vulnerable groups? That's why I talked about, from early on, I outlined the issue of having a conflict-sensitive, gender-sensitive, and an intersectional lens when we're addressing such an issue as access to justice in such a compounded, difficult times as COVID during armed conflict in Libya, in a country that had a long legacy of lacking an access to justice to begin with for the last 40 years. And it's very complex. You have women who are judges, but then there's no access to justice to certain vulnerable groups, including some women. And in which issues? Is it access to justice in all issues, or issues related to gender-based violence? That's another issue. So it's complex, and we need to be patient and not think of quick fixes without knowing the context and trying to address these issues.
To perhaps put a positive outlook on things. Zahra and I do this double act sometimes, so we spend a lot of time together. But I think I would say one thing is the reason why I'm much more comfortable with Nina's suggestion of digitizing laws is because actually that's effectively an informational element, right? That's putting information out there. It's not something that, or a tool that can be utilized to block people's access. One of the things I picked up in my initial intervention was to say, you know, things like filings, etc., don't make sense for some of the vulnerable groups that were pointed out, like migrants who are in refugee camps, where they are living in, I mean, they barely have water to have electricity and internet access. And if it's done, then it's done at an extortionate rate, where they would probably have to pay someone to access their internet. And so what we don't want is to create new barriers of entry to people. So that's the main point that I raised and I wanted to reiterate. However, there are small windows where some work can be done whilst we address the more complex issues. And I think things like making information available that is, like, you know, even for the lawyers, the public lawyers, the private lawyers, so that they can access the laws, they can access the court filings, all of that remotely when they, you know, even for security reasons now they can't travel. Those are positive things because there are not things where you're compromising the data of the individuals concerned. So I wouldn't be comfortable, for example, with me submitting information as an individual to any of these systems, because I do not think we have the laws to protect people's data, and that's a fundamental piece of this puzzle. So we cannot ask people to share information that there's nothing to guarantee being protected. That's one. Two, but something where I can obtain information, that's fine, because that's not compromising me. That might make my lawyer's job a little bit easier. That might make students studying law a little bit easier, who might then come in as volunteers in the civil society role you envisage. So I think in some instances, there are bits of this project which are almost are neutral in terms of their impact, and those should be pursued. But the ones where are either void of understanding the real kind of the real life situation of the vulnerable groups we're talking about, or risk making it more obstructive, those are ones we should take a step back and think about more systematically, I think. I don't know if that helps.
Yeah, Elha, thank you so much for that. And Zahra, yes. And Zahra has actually addressed the second part of the audience question had to do with basically access to the internet by these vulnerable groups, which Zahra has explained to us that many of them, you know, might not even have electricity, let alone access to the internet. But picking up on Elham's points also, it seems to me that so long as we're not creating additional hurdles, additional barriers, putting information on the internet, even though not everybody might have access to it, might not directly help those vulnerable groups in the first place, but might help them down the road, or might help others who might be able to help them because now they have access to this information. And also I would add that digitalizing this type of information laws and putting them on websites certainly wouldn't, isn't meant to be the answer to all the problems, right? It's certainly not meant to be the exclusive approach. It's just, one of the ways in which one might ponder, how to approach these very, very complex issues. But Zara, your point is very well taken about looking at all of this through this lens of conflict and, really taking into account the situation on the ground.
The other, it has nothing to do only with what we're doing. Ever since COVID-19, we've been hearing about digitalized solutions. And in many issues, not only on gender-based violence, on mediation, on local governance, several issues, I've been hearing this. And as if COVID, this pandemic, which has only exacerbated and uncovered the already injustices that we have, and the failure of our systems to address these injustices. But then we're only thinking of digital solutions. We're not thinking of addressing root causes. We're not thinking of issues related to trust. Imagine, even if Libyans had these vulnerable groups and these vulnerable women had access to the internet, would they file in a society that stigmatizes victims of gender-based violence and specifically rape? Where's the trust? Do you imagine that women would file a suit via digital tools? I think there are other issues that needs to be addressed more than thinking of short fixes and solutions like the digitalization. And I totally agree, it could only be for raising awareness, but and for lawyers themselves, making these laws available for them, capacity building, but not as a service provided to the victims of gender-based violence or conflict-related sexual violence, or even their families.
Before I go on to the next question, Ilva or Nina, does anybody else have any other thoughts on this? Okay, I wanted to next ask the following, and this is actually my own, sort of thought or question, and this comes in two parts. First, do you have any thoughts regarding how the newly elected government of national unity might address some of these issues in the best way, assuming goodwill on behalf of the government? What are some ways in which they might be able to address some of these issues, including the issues of trust that Zara mentions, and as well as the other ones that have already been discussed? So Ilva, would you like to start with this one?
No, I think actually Elham and Zara are much better placed to start that. Thanks.
Sure.
No mandate.
I'm going to turn on my microphone just so you can hear me laughing because I'm not sure it's, I mean, Zara just nailed it. I'm not sure it's within their mandate to address this issue, actually. And I think one of the dangerous things we're doing is having conversations where we suggest that this, this kind of work is within their very limited roadmap to the election, and this is what gives them the ability to legitimately claim they need more time. And so I think for me, actually, what I would really prefer is for them to focus on getting us to an election, which is what their actual mandate is, and we leave all of this to the future. And this is not, I'll stop being so flippant. I'll explain why I'm saying this, other than my personal prejudices towards this this government. But I think one of the things we need to establish in Libya is the rule of law, right? It's a fundamental element for any of this to work. For us to establish the rule of law, we need to have institutions that act within their mandates and are legitimate, therefore. And the more we expand people's roles, just because we are lacking formal institutions, the more we're enshrining this concept that everything is ad hoc and everything is de facto, like the whole state is de facto state. And I think it's really the role of us lawyers to say this is not adequate. And the second point is a purely technical point, which is any laws that could possibly be passed to address this, or any measures that could be possibly passed to address this, will be subject to appeal or a question from a constitutional basis because of this question, including, for example, if we pass anything by this current House of Representatives whose mandate expired years ago, if they, in all the goodwill in the world, pass a law, that law is always subject to question because they don't have the mandate to do that. And so I think it's really important for us as lawyers to also remember that our role is to promote the rule of law and to enshrine it in countries we work in. And that includes being brave enough to say, as exciting as this project is, we need to make sure it's done in a legitimate way that further fosters the rule of law and doesn't feed into further undermining the rule of law.
Thank you. Zara?
Yeah, I completely second what Ilham said. The first thing I said, they don't have the mandate. Though they do, in their mandate is to address COVID-19. So that's an aspect, but the recommendations that you have is not within, not even the mandate of this parliament. So I think this, while we will be fighting for elections at the holding the elections at the end of the year, you can work on the gaps in the research, and with hopefully a newly elected parliament by the early next year, we can have discuss all these recommendations to the state, whether reforming the legislative system or the services that can be provided by the new government, but not at all in this time period. But then the question will remain, if there are victims, and you're focusing on female victims, vulnerable groups during COVID, what would they do? What the problem is, the solutions that you're giving, they're quick fixes and they're top down. And that's, again, because this is a typical legal approach in a context of a collapsed judiciary. So that's really challenging, and that's might invite us to revisit our I know for those of you with a legal framework background, insist on it always starts with the state reforming the legislation, but then what if the state is not there, is completely collapsed? Where do we start? How do we protect these vulnerable groups? And that's the area that I wished this report would address. And that's why I was insisting on the context, knowing the context of armed conflict.
Thank you so much. And that's actually a perfect segue, Zara, to my next question. And I said my question sort of had two parts. One had to do with the Libyan government, but then my other question has to do with precisely that. How can the international community, very broadly defined, and international lawyers, be of most help? You know, what are some of the things that we could all do to be of most help? So I'm throwing this out there to all of the panelists. Ilva and Nina, do you have thoughts on this? And if not, I will turn it to Zara and Elham.
And I think it's most appropriate to start with Zara and Elham.
Sure, Zara. Actually, let me follow up with you. What do you think are some things that the international community, international lawyers who are on the outside, what are some of the things that we can do to help, taking this very nuanced approach of, hearing from people on the ground, taking into consideration the conflict situation, the fact that the judicial system has been broken for years, how can we be of help?
Okay, so it's a really very good question, and it can be divided into there could be working on preventive measures, and then working on addressing the violations. Part of the problem of human rights framework in general, the international, is the accentuation of the accentuation on what to do after the violation happens. And that's important, the work especially that international lawyers do in terms of helping in reporting. For example, there could be help in developing mechanisms that ensure that women are not subjected to these kind of violations, and to have access to assistance, ensuring that they have equal possibility to access assistance and to report it. It's really difficult to do so from international in a local armed conflict setting. And maybe the medium would be more in the work that already the UN does under the umbrella of UNSMIL, and maybe if they give more attention to gender-based violence in terms of monitoring, reporting. The other issue is the issue, as I was saying, the issue of having more preventive measures. I don't see that as the case. It's usually we act after the violations, and how to address these violations in terms of the accountability, the justiciability. So that's another area. But I really see that it is a quite difficult thing. Maybe scaling up also financial and technical support to for those groups that address that women, civil society groups that provide legal support to victims of gender-based violence. Improving early warning indicators to monitor and report, address threats of violence against women in publicly, especially positions, and not to allow it. So there are quite a few things that can be done. I'm trying to think more, but these are the issues I would raise at the moment.
Thank you. Elham, would you like to go next?
Yeah, I think one thing I would say, and that's a general piece of advice for international community, is sometimes the work that needs to be done is the really, really tedious, long-term capacity building, supporting, and not the sexy, won't this make great if we just put everything online and make it super snazzy. So I think it's I think the international community to effectively step away from the sexy and go for the more like tedious work of law, which is actually there's much that needs to be done in terms of enshrining the rule of law, and that's the kind of right of work for organizations like the ones hosting us today is to look at the legal reform that is required to make this stuff work properly, the institution building that is needed, the kind of training that is needed. So one of the recommendations is the training of young lawyers, but I also think that there is much training that's needed at the judiciary level to know kind of how to ensure these things work and for them to operationalize these recommendations. So I think it's really exhaling and taking a long-term view to these solutions requires really the really heavy lifting of this. On the flip side, and looking at, I won't talk to the issue of gender-based violence because that has covered a lot of those recommendations that I would have thought of, but looking from the perspective of migrants, and this is a quite a obvious recommendation and perhaps seems novel to say sometimes, but stop sending migrants back to Libya. It's been declared an unsafe harbor by every relevant institution in the international community. We know what happens to migrants that reach Libya. And so instead of talking about how we support these vulnerable groups in Libya, then we stop making them vulnerable groups in Libya as is required by international law, which does not recognize Libya as a safe third haven for migrants. And so, when we're talking about the international community, it's not always their magnanimous generosity that we're looking for. It's them abiding by international law the same way we're asking the Libyan authorities to abide by international law, and that requires the EU to stop outsourcing its pushback policies to Libya.
Thank you. Ilva or Nina, do you have any thoughts on this?
Yes, or it's more of a, I know we're short of time and it's just an issue that I wanted to bring up, and I know that Nisreen Amer, who was supposed to join us during this discussion as well, she was going to speak to that, and it is just to raise the increased use of customary and tribal justice during the pandemic also, and in particular of women, and also how that jeopardizes in a way women's rights and also agency, and just to also to speak to the sort of beyond state institution, and how to sort of a forward looking and looking beyond also the formal institutions, so to speak, and to bring that to the table as well.
So this, can I come in on this? This is a pet peeve of mine with the international community, so bear with me. It's almost, this is not to detract from the effectiveness of some traditional mechanisms in peace building. However, they are not replacements for a functioning judicial system. And I think that is something that needs to be clear. And talking about tribal justice is not tribal justice, it's mediation, it's peace building, but it's very problematic when we seek to say that there are mechanisms that could replace a properly functioning judicial system. So I think that's one thing. The second thing, and this takes me back to my comments about the international community can do, there is almost an Orientalist fetishization of elders. It's like, oh, look at these elders. It's so ethnically satisfying to give them the powers to find peace in their own people, in the local way. And I think that Orientalist narrative of peace building is really frustrating because it also is phenomenally patriarchal. It is, a lot of it discriminates against women in many ways. Zahra is going to step in and disagree with me, but I think in a lot of ways, these elders tend to be men. And I think it is really important that we stop having this two-tiered system of justice, of what, the justice of brown people and the justice of white people is very different. You would never go to a situation in Europe where there's a conflict and require that they have their elders find an alternative system of justice. And so for me, and this is a particularly, I think it's a colonial approach to justice, and I think it's really dangerous to accommodate that when we're talking about proper rule of law function. Sorry, it's a real pet peeve of mine.
Thank you, Elham. Nina, any last words on this?
We don't have time, and I don't want to go into details, but many of the issues that were raised by previous speakers concerning concrete examples how to deal with gender-based violence will be covered by the program that we started implementing, and we hope that the tools and different materials that will be developed under the program will help in long run to address those issues. But overall, the international assistance is quite limited in the format, and only global vision and the policy that is implemented locally and supplemented by international actors can lead to real solutions. And I hope that this will work this time much better than in previous periods. Thank you so much.
Thank you so much. Unfortunately, we're out of time for today. I would like to encourage all of our audience members to consult the ILAC report, which the link has been provided in the chat. And as I mentioned earlier, it is also available on the ILAC website and through their social media. And I would like to thank all of our panelists for spending time with us today to discuss these very important and difficult issues. Thank you so much for joining us, and I hope that our paths will cross again in the near future. Thank you.
Thank you.
Thanks a lot.
Thank you. Good luck.